I always like to explain which kind of perspective I use, and that is the children's rights perspective, obviously, being a children's rights professor. But I think it is also important to take that starting point, because without children's rights, we would not have been able to talk about child-friendly justice. Child-friendly justice really comes from children's rights, and children's rights have many implications for children in conflict with the law, juvenile justice, child justice systems, whatever you call it. There is a clear call for specificity and specialization. Children are different, require a different approach than adults. We are talking about adolescents, mainly roughly between 14 and young adulthood. I think we now much more are concerned also about the transition from childhood into adulthood. Childhood doesn't really stop at 18, at least not child development. So we are now also much more aware than before that we need to consider young adults in our approaches as well. We are talking about pedagogics because that matters. We are talking about reintegration, education, and of course, always very important, protection, for example, against violence. Deprivation of liberty, we don't like to see that in the juvenile justice context. It is happening, it is used, it will always be there, but the message from children's rights is extremely clear. Last resort, it should actually be the alternative rather than the other way around. And then, of course, a very important critical element is fairness, is fair trial, is due process. And that's where child-friendly justice comes in, because it's primarily a vehicle to secure that we treat children fairly and in such a way that they can participate effectively in the decision-making that is about them. And that is relevant also for the realization of the core objectives of juvenile justice, reintegration and pedagogics, but it is also a matter of fair treatment. And fair treatment is a right of the child. So it's a very, in other words, child-friendly justice can count on a very strong legal basis that is not without commitment. Although some people say, well, the directive is more important than the guidelines, yes, but the notions underlying the guidelines as well as the directive are of equal legal relevance. And you see that also the European Court of Human Rights, for example, is becoming more and more informed by child-friendly justice as a concept, regardless of where it is ultimately to be found, in guidelines or a directive. We have seen a lot of progress in the past years since the CRC was adopted already, but particularly in the final 15 years in Europe. And children's rights, on the one hand, have confirmed the domestic assumption that children are different and require special attention, and it has stimulated a lot of reform. And juvenile justice, child-friendly justice has been part of that. We have now, today, a much stronger scientific basis for our work around child-friendly justice. So where we initially were basically building on principles laid down in a convention and assumptions that were somehow present in our domestic systems, because juvenile justice systems, of course, date from the early 20th century, we have now a much more stronger scientific basis for the meaning of this all. And some observations in that regard relate to that it's crucial to recognize that children are lesser culpable and that they have, they have this ongoing process of development way into the 20s. We see that a pedagogical intervention is much more likely to be effective rather than an imprisonment, for example, or a very repressive way of approaching children in conflict with the law. And we also see that it is absolutely important to include children in the proceedings and to make sure that they know how to participate and that they are heard and that there is also feedback back to them in order to secure that they support the outcomes, that it is beneficial for their reintegration and also ultimately for the effectiveness of the intervention. But it's also contributing to the sense of justice. And that is a very important component, that the sense of justice of the actors, including the child, is promoted. COVID-19, I think, has challenged us in many different ways, but also in the justice system. So I would like to flag that as part of our discussion today, is that, you know, even though we are in a way looking back at a positive development and we need to move forward, we need to take into account that at the domestic level, the systems may suffer from COVID-19 impact. And that means that we may have to do one step back in order to be able to move forward again effectively. That is something that I just want to flag. So child-friendly justice is, as you all know, I'm not going to dwell on that, a concept that is actually meant to enable children to access and engage with justice systems broadly, not only juvenile justice, but broadly. And if you have to bring it back to its very core, it is about accessibility. It's about how children can access justice and also seek remedies, for example. It's about accommodation. How can we make sure that children are accommodated well into our systems, being formal, being informal at stages, but generally being also very adult oriented rather than child oriented. So it's about accommodation. It's about responsivity, being responsive to children, being aware of their level of development, being aware of their limitations to participate without extra help or without support, being also responsive to their resourcefulness, to their possibility to change, in rather than stigmatizing them as being delinquent or being the other child or being that migrant child. No, this is about responsivity to the fact that we are talking about resourceful, resilient, powerful children that still have a whole future ahead of them. It is about accountability, so making the system accountable. That's also where lawyers come in and legal aid. And it's about remedies in case of rights violations. Think of violence, think of unlawful deprivation of liberty, think of ineffective means to participate effectively, which may undermine the right to a fair trial as a whole. What can you do as a child to challenge that? That is about remedies. And then finally, it's also about empowerment. It's about making sure that we do not only deal with children, but that we make sure that they are equipped to participate effectively in their own name. So that also means that they have to have information, support, measures to protect them, and also, for example, language that they understand. So this is in a nutshell, I think, what we are talking about. And every single lawyer working in the system should understand these core elements of child-friendly justice, the relevance of child-friendly justice, and also the more concrete ways to promote these specific elements. And that's where the guidelines come in, as well as the directive, which you discussed, if I'm not mistaken, earlier today. So key elements that you find in the guidelines are listed here, and I think they are cross-cutting. So when we talk about legal aid, when we talk about the support of lawyers in the domestic system, we need to talk about these different key elements that should be addressed, because to focus only on legal aid is too limited. To give you an example, information is absolutely crucial. And it's obviously the child's lawyer or other legal assistants, paralegal. I saw one question in the chat box, paralegals, could that work too? Yes, it could, but only if they also understand the significance of information. So the lawyer has, or the paralegal has, an important role to play in translating the legal realities into language that children understand. And of course, there you have to bear in mind that the child does not exist, and that a child may not understand the language used in the country, or may have difficulties to understand written language, for example, more than oral language, just to give you some examples. The right to be heard often required, another example, requires to be assisted. by someone who the child trusts. The lawyer can perform that role. So in doing so, you are connecting not only to the core element of having a lawyer, but also to the core element to have the right to be heard, recognized. So I just throw this at you, this list of elements that can ultimately all together contribute to these core components of child-friendly justice, such as accommodation, responsivity, empowerment, etc. Conscious of time, I just point out that this is not only something that develops at the European level, but that you should be aware of the fact that the Committee on the Rights of the Child has also adopted this notion also into its recent general comment number 24. And if you browse through that general comment, and I'm sure you all have done that, there are many places where there are references to elements that are relevant for child-friendly justice, including the lifting of the age to 14, the age of criminal responsibility. It's very interesting that the Committee on the Rights of a Child explicitly connects that to the possibility of children to understand proceedings and to participate effectively. And that is a very strong extra argument why you should actually promote the establishment of an age of 14 or higher rather than a lower age. I already mentioned why this is also very relevant. But how can we make sure that we reach out to all children? Article 2 of the Convention on the Rights of a Child, I'm sure it has been mentioned already today, is one of the general principles that are actually about the prevention of exclusion on the basis of gender, migrant background, ethnicity, or on the basis of what parents do, for example. And I think this has many implications for child-friendly justice. And I think the next 10 years of child-friendly justice implementation should accommodate differences. And when I say that, I mean that it should, on the one hand, recognize that children are different. Also within the group of children, there are different groups of children requiring different kinds of attention. But at the same time, that is all meant to serve the overarching objective that all children should benefit from child-friendly justice. So 3 points of attention to start with. When we talk about the inclusion of all children in child-friendly justice, we need to talk about all systems that are relevant for children, not only about the criminal law system. In many jurisdictions, and I'm sure you recognize it, the different systems around children, child protection, youth care, mental health, immigration, criminal justice, they communicate with each other. And children in the criminal justice system often have a history in the other systems or one of the other systems. So if you, and also, for example, diverting children away from criminal justice may mean that they end up in a different system. And that means that if that system is not child-friendly proof, that you may run into trouble anyway. And lawyers should be aware of that. They may also need to add to the assistance if the child is moving from one system to the other. So that's the first point. The second is we have to recognize the different groups of children that are at risk in this whole story. The most marginalized groups in society, such as girls, such as children with disabilities, physical as well as mental, children with different ethnicity, children with learning difficulties, children in the child protection system. There are so many groups that do not connect to our mainstream approach to children that we have to make sure that we recognize the existence of these groups and in light of our ambition to address them all. And then finally, that point I just made is that within these groups of children, there are so many differences requiring different forms of attention that we should be very clear on what we are talking about in order to ultimately comprehensively include everyone. So, for example, the specific focus on girls matters a lot. The response of many governments, however, is that there are too few girls in the system to give them devoted attention. I'm sure you recognize that. that is never an argument for not focusing on girls, but it's rather an extra investment for government to make sure that also these children, girls, can benefit from the rights that they are entitled to, etc. So it is really important to talk about numbers and about and about the group we are actually concerned about in order to make sure that we do the right thing. I could give a similar example regarding children with mental health problems, for example. Going to the professional, and that's what I do in my final 1 minute, is to I give you a list of 5 critical elements that every professional in a juvenile justice system should actually take at heart. And I think ultimately legal aid, or within that, the lawyer or the paralegal or the other legal assistant, is a key professional, a key actor that can bring together these 5 critical issues. 1, the responsivity issue. Wherever we come with our research, and we are currently working in Georgia, for example, we see that the lack of responsivity is critical. Lawyers are somewhat aware of rights of children, but they are not fully equipped, not specialized enough, or they cannot rely on other specialized services in order to really secure a child-friendly support. So we need to address specialization, and we need to address the mindset. And this mindset is about perceptions, assumptions, stigma, and that is really absolutely critical. So you can have the most beautiful laws, but without that, it's not going to work. We need to think about our protective elements to enable children to participate. And the lawyer certainly is one. So there, for example, the question comes in regarding the waiver of legal representation. To what extent is that still sustainable? It may go beyond the ideal maybe of children choosing their lawyer and maybe choosing not to use one, but you could also defend the position that protection is needed in order to make sure that the child can actually participate effectively. And that means that you may want to advocate for mandatory legal representation. The directive is addressing that, but not as clear as it was originally intended in the proposal by the Commission. Information, critical, I mentioned that. Access to justice, the lawyer should not stop working when the case is over. It should stay on board. It should stay in sight in order for children to also consider access justice and seek remedies to secure accountability. And this is a challenge in practice because many of the legal aid schemes do not provide for financial support there. So you need to look into that. And then finally, this is absolutely critical, also the lawyer should see the child as a meaningful actor. And that also means that the child could instruct the lawyer. And there the balance comes in around is the lawyer protecting the child at all costs, independently of what a child thinks? That is a too limited approach. You need to also consult, liaise with your child as a client in order to make sure that you do the right thing. So I hope I sparked your thinking. I hope I gave you an overview of where we come from, where we stand, and how we can start to become more inclusive. And I hope it in one or the other way connects to what you are actually doing as part of your daily work, which in my view is absolutely critical. So thank you for that.
Thank you, Professor Lippard. Indeed, I think it was necessary that you invited us to think more broadly of not only to legal aid for children in conflict with the law, but to legal aid as a part of a bigger challenge, which is child-friendly justice, and not only when children are in conflict with the law, but in every situation in which a child can be in contact with the law. I don't see right now new question in the Q&R part. I will let maybe the time for participants to write their question, but maybe I can first give the floor to the panelists. Does someone have a question for Professor Lippard?
Yeah. I see one question from Ruta. I'm not sure if I pronounce your name well in the chat.
Yeah.
Can I pick it up or?
Yes, please.
Yeah. So it's connecting to, I don't know whether the others see it, but it's connecting to the question, how can you make sure that the different systems that are in place for children?
Okay, please, I will read the question because I'm not sure everyone sees the chat. Sometimes when you're on your phone, you don't. So the question from Ruta from the Law Institute of Lithuania is, what do you think what institution could coordinate or be responsible for the collaboration of different systems?
Yeah, and this is very important. I think there is in general an enormous disconnect between these systems, and there you have a role for the government, but I think you also have a role for the legal profession as a whole. So not the professional independently, but as a whole. So for example, the Bar Association should also think much more about the integration of the different fields of expertise within legal aid. So instead of supporting specialization, for example, only or exclusively in the criminal justice context, you should think about combining the different contexts that are relevant for children. So for example, your requirements towards lawyers assisting children should be around knowledge as well as expertise or experience in, for example, both the criminal justice context and the child protection context. So for example, if you expect that lawyers go to a training on a regular basis, that training should not only be about criminal justice, but it should also be about, for example, child protection, youth care, family law, so that they understand what is happening there. Moreover, it should not only be about law, it should also be about the social infrastructures there. So what kind of programs are available? What is it actually when we say that a program should be effective and evidence-based? What does that mean? What about multidisciplinarity? What is my role as a lawyer there? So it's very important that the legal aid board, yeah, it depends a bit on the system, but let's assume that the legal aid board has influence, that they promote that lawyers work across the systems and at least be trained in such a way that they understand the other systems. And it's actually also the other way around. So for a family lawyer, it might be very helpful to know much more about the other systems. So that is what the legal aid community can do themselves. In addition to that, I think the government should also promote much more interaction between the different departments. So between justice and welfare, and between corrections and education, and that requires government coordination. Yeah, one way of doing that is through a special minister for young people, for example. But that is, we're talking about the lawyers today. So I think the legal aid board and lawyers themselves, they can do this. And of course, it could, sorry, please go ahead, Eva. Yeah.
No, it's okay. I just wanted to, I think there is a new question. But if you want to add something for the previous question, please go.
Well, the first question, I mean, it doesn't really help if lawyers do that on their own. It would also be helpful if there are judges on the other side, for example, that also understand the other systems. So one of the questions is, if you talk about specialization of judges, what do you talk about? Is it about knowing everything about children's rights and child development and criminal justice, or could it also be children's rights, child development, criminal justice, and child protection? And I think that would be very beneficial for ultimately the responsivity of the whole system. And for a lawyer, it's easier to promote a solution, for example, in the child protection sphere, in response to juvenile delinquency, if there's a judge on the other side that understands the relevance of that. So the lawyer is not on his own or her own.
Thank you. So the next question comes from Marcus Angula, and so he says, thanks, Professor, for that wonderful and extensive presentation. Very inspiring. My question is, how can legal aid lawyers actively participate in diversion and also further support rehabilitation and reintegration of children?
Yeah. Well, that's a good question, Marcus. Thank you. I mean, what is absolutely critical is that lawyers are fully informed about the different pathways to reintegration. And they are probably often very much aware of the formal way, going to the court after prosecution, court, and then sentence. But the diversion ways are not always that clear. And sometimes lawyers can also come in too late, or they come in at a stage where they instruct their child in such a way that diversion is no longer an option. For example, when lawyers are involved in the police hearings in the very beginning, and I hope they are, but they instruct their client to say nothing at all, then that may stand in the way of going to a diversion program. But they need to be aware of that, because if they are not aware of that, it's not part of your strategy, it's part of your one-sided approach. But if you know it, then you may consider advising your client to say a few words more in order to enable him or her to go to the diversion scheme. So the lawyer should be very aware of the pathways to reintegration, which for children, of course, informal and outside of court pathways are critical. So that is a very important one. Rehabilitation, or I prefer to use the word reintegration, after a sentence, it's much harder. There's probably a lengthy process, may even be a custodial sentence, and reintegration there is more difficult. So children have a serious interest in being diverted as soon as possible, and the lawyer has to support that. So that is the question to Magnus.
Thank you, Professor Lieffard. If there are no other questions, okay, I think there is another question in the Q&A from Manon de Terouagne. Thank you very much for this really interesting presentation. My question is, what is your opinion about bringing in psychologists and or social workers to help lawyers in the accompaniment and understanding of the children confronted with the system?
Yeah, it's a very good point. I like to see that more and more. For example, in the family law systems, there is already a lot of interaction between lawyers and mediators, for example, but also lawyers and psychologists. There are even law firms that have psychologists in their service. The good thing about it is that you have already easy connections that can help you to support good advice, but also to provide the courts and also the prosecutors with real solutions. So every now and then I sit as a judge myself, and it's very helpful if there's a lawyer in front of you that presents to you a credible solution. And of course, a lawyer, it's not easy for a lawyer to come with such a solution independently from psychologists or social workers support. So it's either organizing yourself as a lawyer together, maybe teaming up with social worker, or it is trying to get to the place where the decision making from the side of the probation service is being made, so that you sit at the table where your client is being discussed. And that, of course, requires that the lawyer is not only concerned about the legal nitty-gritty details of the case, but also about real solutions. But it's important to promote among your professionals as well, in your trainings, that for a lawyer, they need to think beyond being a lawyer. They need to think beyond being the safeguarder in the legal sense. It's also about their initiative to come up with credible solutions for children that are also accepted by the courts ultimately. And that's a bit of a challenge, but you see that in the family court environment, it's much more common. So why not here? And there, yeah. I also saw a question from Albania on for example, on Roma children, and I recognize that, and it's one of the groups that I mentioned. We need to identify, we need to agree, we need to see that there are Roma children in the criminal justice system, and we need to recognize that. And we need to make sure that we tackle the stigmatization of this group. We need to make sure that we see these children as children like all the other children in conflict with the law that require such an intervention that enables them to have this, what the Convention on the Rights of the Child calls constructive role in society. If we don't do it, government officials should and also the public should be willing to accept that our approach towards Roma children in the context of criminal justice is very likely to be ineffective. And that is not in the interest of society. We don't like to recognize that, and it is absolutely an example of discrimination, exclusion in its most heinous forms in Europe, I would say. But it's absolutely important to make people and the public also aware of the fact that if we do not give them the attention they need, that they will not reintegrate well, and that means that we are in trouble. And that's what I personally very much like about the committee's approach in General Comment number 24, where they say investing in the rights of children is in the interest of society. But we have to make sure that we invest in the rights of all children. And that's also the point I wanted to make today.
What a great conclusion, Tom. Thank you. Thank you very much for your presentation.